and Ms. Botha. They are led by the Deputy Minister, Honorable John Jeffrey. You are all welcome to this meeting. And honorable members, you are forever welcome, and everybody who is watching us from home, you are all welcome. Over to you, Mr. Dupree.
Good morning, Mr. Chair, members of the committee and the Deputy Minister. I will share the screen. There we go. So I presume, Mr. Chair, we can start where we ended yesterday, and that is with regard to the definition of characteristics. And at the conclusion of having gone through this definition, I think paragraph P was not discussed by the committee. So I don't know whether you would like to open the floor for sexual orientation, gender identity or expression, or sex characteristics to be discussed, Chair.
Thank you very much. Are there any hands?
Chair Swartja.
Honorable Swart.
No, Chair, I appreciate that we're dealing with hate crimes under this section and that this is a targeted group. I just wanted to get a better understanding of the terms. Gender, is it gender identity or gender expression, and sex characteristics? Obviously, we would also need to have a discussion about these additional items when it comes to the grounds, because those, if I understand it correctly, are under the grounds as well, the extended group. So I just wanted to get an understand from Mr. Dupree about the terms gender. Is it gender? It's gender identity or expression. Is it gender expression? And what is meant by gender expression? Thank you.
Thank you, Honorable Deputy Minister.
Yes, Mr. Dupree will know why I'm stepping in on this issue to relieve him of the issue. But look, these terms are sexual orientation is obviously who you're sexually attracted to. So that would be lesbians, gays, bisexual people. It's actually gender expression or gender identity or gender expression refers more to transgender people who've been born one sex, but actually identify with the other gender or want to express themselves as being part of the other gender. So it deals more with transgender people. Sex characteristics is the term again internationally, which is given to intersex people who are born with sex characteristics of both sexes. So it's an international term. I mean, the acronym is SOGIESC. I'm not sure whether I thought gender. I don't think. Gender identity was under H. So it was there before, but the correct issue is gender identity and gender expression, and then intersex was under sex, including intersex. But as I said, the internationally recognized term for people that are intersex is people of different sex characteristics. So that's I don't know if that assists Mr. Swart.
Thank you very much, Deputy Minister. Honorable Yako.
Thank you very much, Chair. My understanding is that gender expression and gender identity is not necessarily tied specifically to transgender people. I feel it's a broad spectrum, and it could affect those. I mean, you have a heterosexual man who perhaps likes to dress in a certain way that is an expression of himself, which is not the norm for heterosexual men. So that's how I understand it, as gender identity and expression are a little bit two different things. And they are broad across the spectrum. They can apply to heterosexual people, as well as people who fall under the LGBTQ community.
Thank you very much, Honorable Yako. Honorable Nevo Trojan.
Thank you, Chair, and thank you to the Deputy Minister. I wanted to ask about the "or" that is in the phrase. Why is it not sexual orientation, gender identity, comma, gender expression, comma, sex characteristics? Why is the word "or" used? Thank you, Chair.
Thank you very much, Honorable. Minister, is your hand up, or is it an old hand?
Sorry, it's an old hand, but maybe shall I respond to Honourable Nevo Drushan's question now? Or are there other people who want to speak?
There's no one who wants to speak.
Okay. No, just to say thanks to the Honourable Yako. No, I think she did express it better than I did. Gender identity would be what gender do you identify with, and that can also be gender neutral, but that's where transgender would come in more. Gender expression would be how you express yourself in terms of the clothes you wear, as Honourable Yako had said. The "or" is because people don't generally have all of these together, if you see what I mean. You can have sex characteristics of both sexes. You can, well, I don't know, yeah, so you can have that. Some people would identify with the other gender, the other gender to the sex they were born with. Some people would be wanting just to express themselves as the other gender. So the "or" is correct.
Okay. Honorable Swart.
Thank you, Chair, for the explanation. I just also, the question of the "or", I'm not sure if it reads correctly, but we can discuss that at a later stage. I understand it's the second "or", but the first "or", I'm not sure about that. But we'll leave it for the time being. I have my questions have been answered. Thank you, Chair.
Thank you very much, Honorable Yako.
No, thank you, Chair. I think I do agree with Honorable Nevo Drushan when she speaks about the "or". I'm not fully covered that it's in fact needed there, because it could be just a comma, gender expression, or comma, sex characteristics, and then I don't. Yeah, so I'm with her on the issue of the "or". Yeah.
Okay, thank you very much, Honorable Yako. Honorable John Jeffrey.
Yeah, Chair, this is an international term. So what I would suggest is that we check on internationally, is it gender identity and expression, or gender identity or expression, and we follow the international terminology.
Okay.
So I'm saying let's, in a sense, it's responding to Mr. Swart's suggestion of let's then check that out to make 100% sure. and follow the international terminology. So if internationally they use an and, gender identity and gender expression, or an or, we follow that.
Yes. No, thank you very much, Deputy Minister. Ms. Potter.
Thank you, Chair. Just following on what the DM has said, I've looked up a glossary on SOGIESC, and this was issued by the Council of Europe. And the terminology, the phraseology that they use is sexual orientation, gender identity or expression, and sex characteristics. Thank you.
Thank you very much. So let's move from that one. Before we go to grounds, I think Honorable Horn wanted to raise to raise something yesterday. Honorable Horn.
Yes, thank you, Chair. I think both the Honorable Swart and myself indicated that due to connectivity issues, we were not really present when I think the second and the third characteristics were no, the third and the fourth, birth and culture, were, I don't want to say passed over, but dealt with seemingly without anybody raising any issue. Don't know where, is that my cue to proceed, Jay?
Sorry, I was muted. You can proceed.
Okay, yes. Thank you, Chair. In respect of birth, the information supplied to the committee in an attempt at justification by the department was two court cases relating to the decision of people who drew up a last will and testament to exclude either adopted or adopted children or children who were born out of wedlock. And we at the times already indicated that in no way can substantiate the type of systemic discrimination against a group of people, an unmutable group of people, that can lead to justification of the inclusion of this criterion. That was done only verbally on the day. So I don't know whether the department has any other information to supply or put on the record that can inform a decision to include birth, but from our assessment of that verbal input on the day, I don't think it is something that then indicates the type of systemic discrimination and discrimination that leads to the commission of crimes against people based on their specific birth as a characteristic. Thank you.
Thank you very much, Mr. Dupree.
Mr. Chair, with your permission, I'm going to hand over the hot seat to Ms. Botha. You will recall that the department did submit additional information in the note that we have most recently submitted to the committee. But with your permission, Mr. Chair, I would like Ms. Botha to lead us in on this discussion, please.
No problem.
Thank you, Chair. Just to answer one of the issues that was raised and whether we submitted the note to include those cases on birth and the additional case that we found on language. We did talk through this on in the previous meeting. The meeting on Friday. We did talk through and go through the notes, including those two additional cases that I added verbally in the meeting prior to that. on birth and the additional case on language. But the cases on birth were found just to indicate that there are instances of sort of discrimination, and that there is vulnerability on the basis of birth. And if we track back to the rationale for legislation like this bill, one of the victim selection sort of categories is vulnerability. And so these cases were just selected to show that there is an element of vulnerability which attaches to issues of birth, and how the courts have dealt with that. So they were included for that purpose. I also just want to point out that in the notes that we have previously circulated to the committee, where we set out some of the grounds and characteristics, and we track that back to section 16.293 of the Constitution and Pepuda, that birth is contained in section 9.3 of the Constitution as well as Pepuda. I'll leave it there. Thanks, Chair.
Thank you. Any takers?
Chair Swatcher, I understand the justification. I also understand that the word birth is contained in other legislation. But if you apply the sense, and I know the DM might say there's no harm in adding it, but I just don't see this as a group that is being targeted as such. If you look at your offense of hate crime, where motivated by a person's prejudice or intolerance towards a victim because of birth of the victim, I find it hard, and I know that I think this is one of those gray area ones like age, but whether those two cases actually, I can see that there might be a form of discrimination, but it seems so limited. Whether that then justifies the escalation of this to a characteristic for hate crimes is debatable. Maybe we must just put a question mark and flag this. I would think that it could be a targeted group if you are birthed in a certain ethnic group or something, or gender. And I suppose it's not only at the time of birth or as a youngster, it is going on through your whole life, or you could be a targeted group because you were born in a certain race or a certain ethnic culture. So yes, I find it hard to justify, but I can understand there could be some rationale for it. Thank you, Chair.
Thank you very much. Deputy Minister, do you want to something on this one?
Yeah, what I was just going to say is, look, I mean, remember 9.3 is around discrimination. Yeah, it's about discrimination, which is not necessarily, and discrimination does not necessarily result automatically in hate crimes being committed against you. So pregnant women get discriminated against, but they are not really victims of hate crimes in terms of women being attacked just because they're pregnant. So this may be, but the suggestion would be, why don't we do what we did to age? Option 1 include age, option 2, sorry, option 1 include birth, option 2 exclude birth, and members can consider it and as it when the list is fine. I just want to suggest that. I don't know if I can go on to culture, whether I need but to motivate why that is there, or whether we should hear from Mr. Horn, who I think was going to raise issues first.
I'm not sure, DM. I mean, I think with respect to others, there was generally a clear, distinct views, well motivated, but members could not find each other. But my listening of the motivations on birth, I don't see it. There are clear, distinct views, well motivated. It's just on birth that we can create options. Maybe let's put a question mark, because I think even your explanation, in a way, it's not as well spirited as you have been defending the others. So I'm not sure that I can just say that we can just go to options with Beth. Maybe we can come back to it. Maybe there will be more. Maybe there might be more facts or reasons that can make us to consider it. Would that be fine?
Chair, that's fine. I don't have strong feelings on birth. That's what I was trying to say. But if nobody, I mean, so it's an issue of take it out now, I guess, or as Mr. Swart had suggested, leave it in and let it be considered, but it's possibly on the list to be removed.
Okay, so members, if we remove it, will there be any objections?
No. No, Chair.
No objections. Let's remove it.
Chair, Honorable Neo Druchen.
Honorable Neo Druchen.
Chairperson, thank you. Yes, I think I will object because maybe for now we should leave it there. You know, there was a case in court where a boyfriend had hanged his girlfriend, you know, on a tree, or, you know, maybe we don't see it as a hate crime. But yeah, I don't know. If there is a conflict in relationships, and you know, I've impregnated my girl, it's going to cause too many problems in my family. I'd, you know, rather kill her. People think it would be easy to just impregnate women and then kill them. Yeah, I would prefer that it stays.
But how will it be under Beth?
Chair, maybe if I can come in, I think Honorable Nivo Drushin is speaking about pregnancy, which is not on the list. And that is not there because, yes, and I think it's the Tsegofatso Pule case where her boyfriend, well, he's been found guilty, he's lost his right to, I mean, he's had his leave to appeal rejected, killed her because she was pregnant and because she wouldn't have an abortion. But that wasn't, the argument would be it wasn't in the broader category. Yes, her pregnancy was a factor which motivated him to kill her, but he wasn't after pregnant women generally. These characteristics are around more general matters. You get attacked because you are Black, that's all. Not who not the person who you are. They're going for a Black person, as it were. Whereas I think in the case of pregnant women who get killed, it's specific to that case. You've had other issues where I think there may have been attempts by ex-girlfriends, wives, to kill the new girlfriend or wife, and what drives them over the edge is that she's now pregnant. But again, that's specific to that case. You're not, other people, other pregnant women are not vulnerable. I don't think the, what's the accused name? Is it Shoba? He wasn't going to kill any other pregnant person. He was only after his girlfriend.
No, thank you very much, the Honorable No vote, Johan. Are you still of the view that we should leave it and not remove it?
I understand. I do understand what the GM is saying. Yeah, I'm still, yeah, no, okay. Still processing, but yeah, no, it's fine, Chair.
Thank you very much. Let's move to culture. Honorable Swart and Honorable Horn. You said you're going to raise issues on birth and culture.
Chair, yeah, I was waiting for the Honourable Swart to go first. Now, I just wanted to raise the issue that there's, of course, no, I want to say, single understanding of the concept of culture. I mean, yes, I've taken note of the fact that, of course, in terms of some other of the characteristics like gender identity or expression and sex characteristics, we also had to I want to say, obtain a explanation today. So I see there that Mr. De Pre has gone there. Quite possibly I was then absent, because that was also going to be my submission, that if we are going to include culture, then I just think we should add a definition of it ultimately. So if that is to follow, then I'm covered. Thank you.
Thank you very much, Honorable Swart.
Yes, there was I missed a brief discussion about that. If it took place, I was offline, and I do understand there is a difference between culture and ethnic or social origin. There was broad discussions around that issue as well, and about race. So I don't have any major objections to it being included, given that this is a characteristic of victims. So the question is, to what degree is it covered by ethnicity or social origin? Maybe I just need to clear that up in my head. Maybe the DM can just help me in that regard. Thank you.
Thank you very much, Deputy Minister.
Chair, thanks. Yes, I mean, I was just looking at the dictionary definition. I mean, obviously this culture is in the arts and manifestations of human intellectual achievement regarded collectively. But what we're talking about here is more the second definition of the ideas, customs, and social behavior of a particular people or society. So just in response to Mr. Horn, I think that it is generally known what culture is. Just responding to Mr. Swart, obviously there's an intersectionality between people of a different culture, maybe of a different religion, a different race, a different ethnic or social origin. So in all of these, there's intersectionalities. But let me just give one example of where people can be victimized because of their culture. Some people from other cultures may find something that you do, some of your cultural practices upset them, and that causes conflict. So a more common occurrence would be a particular neighborhood is of a particular race, maybe white. There's a black family who want to follow traditional practices as far as the slaughter of animals, for example. That then causes tension and this conflict between two groups on the basis of culture, those in favor, those against. Yes, that would be, I've raised the issue of black family. That would be issues of race, that would be issues of ethnic or social origin. But you do also have a situation where we have white Sangomas who would follow the culture relating to Sangomas, and they may be living in that area, and they may want to sacrifice an animal, slaughter an animal rather, and that then upsets the neighbor, and that is then only culture. It's not race or ethnic or social origin, because they're white. They've happened to have adopted another culture. I don't know if that explains it. Thanks, Chair.
Thank you very much, DM. Honorable Swart.
Again, it's one of those gray areas. So I'm not going to pursue it further. If the committee was happy with that, then we can go on. Thank you, Chair.
Thank you very much. I think we are done with the characteristics. Can we go to the grounds?
Sorry, Chair, before Mr. du Preez comes in on the grounds, I think it might just be useful to give the context, because these are the grounds for hate speech.
Yes.
And if I can just briefly do that, because I think it will aid the discussion around what grounds are allowed in. So basically, a hate speech is a person who, and obviously this wording the committee will come on to later, but it's somebody who communicates, says, does whatever, something that could be construed to demonstrate a clear intention to be harmful or to incite harm and promote or propagate hatred based on one of the following grounds. So that's the definition of the crime of hate speech. There is then a partial exemption. So basically, you've committed hate speech if you have shown a clear intention, demonstrated a clear intention to be harmful or incite harm and promote or propagate hatred. There's then a partial exemption for academic or scientific inquiry, reporting in the public interest, bona fide interpretation, proselytizing or espousing of any religious tenet, belief, teaching, etc. And that's a higher bar that is in for those categories because of the importance, well, freedom of religion, academic freedom, freedom of the media, particularly. And that higher bar is that you can't say things that you can't advocate hatred that constitutes incitement to cause harm based on the grounds. And that's taken from section 16.2, I think, in the Constitution. So, Chair, I just wanted to give that by way of background. Obviously, now with the characteristics, there were less sort of impingements on people's general human rights because you had to have committed the underlying crime. On the issue of hate speech, it is affecting people's right of freedom of expression, which the Constitution does limit in section 16.2 to 4 grounds. And in Kwelane, it's said that it's acceptable to add other grounds. So, for example, sexual orientation. So, in considering the grounds, we've got to consider we've got to include grounds that are particularly serious, and that's effectively what we've tried to do with the proposal that is added. So I just wanted to give that by way of background to lead into Mr. du Preez's input. Thanks, Chair. If I can hand over then to Mr. du Preez.
Thank you very much, Deputy Minister. Mr. du Preez.
Mr. Chair, I don't think I really have anything to add at this stage. I think that the Deputy summarized the whole issue perfectly. Maybe just to mention to the committee that these grounds, let me go back. This definition of grounds is actually the definition that was part of the introduced version of the bill, and it only aimed to exclude occupation or trade and political affiliation or conviction. So that would mean that it will bear the same meaning as the definition of characteristics, except then of course, for paragraph A and B. Now, what the department has done or would like to propose to the committee, that the list could possibly then be shortened to those most important instances where hate speech can then be committed. And this is the list that the department would like to propose to the committee for consideration. Thank you, Chair.
Thank you very much. But if just I may, I raised this issue yesterday, that under Universal Declaration of Human Rights and under International Convention on the Elimination of All Forms of Racial Discrimination, the issue of color is included. Why has it been excluded under grounds? Because even from the literature, in fact, even from the document that you did for us, there was quite an extensive motivation for color from an international perspective. Why have you excluded it under grounds?
Mr. Chair, I think I think in order to try and answer your question is to say that in section 9.3 of the Constitution, we do have color as a listed ground. I don't think that the department would necessarily be opposed to including skin color, but we will be guided by the committee, Mr. Chair. This was a proposal from the department side to focus on those most serious grounds that there are. Thank you, Chair.
Thank you very much.
Chair, can I just respond on the color issue?
Yes, Honorable Deputy Minister.
Yeah, look, with this new or limited list, we're trying to limit the grounds that constitute hate speech, because it is a limitation of freedom of speech. We'd originally left out political affiliation or conviction. As I'd said yesterday, people get killed because of their political affiliation in terms of lack of tolerance. But the reason for taking it out is because we don't want to affect political debate. Can be quite can be quite robust, as I think members will know from the House, but also when it comes to electioneering. So the reason for taking it out wasn't that it was a basis for saying that it's not a serious issue. People don't get killed as a result of hate speech on political affiliation, but it was just limits the ability to engage in political debate, which is important. On the issue of color, I mean, as Mr. du Preez has said, if the committee is of the view that it should go in, then obviously it can go in. But the issue was that this discrimination against people on the basis of color, there's harm that can be committed against them. But it's less of we thought it was less of a hate speech issue. But anyway, it's up to the committee to if the committee wants other ones in, that's not a problem. Thanks, Chair. Thank
you. I just thought that, I mean, reading that document that was prepared by Mr. du Preez and the team, they spent quite a considerable amount of time listen for the color, so I found it weird that they would exclude it undergrounds, because I mean, I think there is also some literature that was taken just to motivate, from the international perspective, to motivate for the issue of color. So if there is no objection, I would recommend that we include it.
Yes, Chairperson, I think we should include it, Honorable Mayor Jochen.
Thank you very much. So are we fine with the grounds?
Chair. Chair.
Is it Honorable Yako?
Yes, Chair.
Yes.
I just have, with your permission, I just have a small ask in terms of what the Deputy Minister spoke about, which was incitement. I don't know if I've asked this question before. However, I'm not quite clear who determines what incitement is in the case of hate speech.
Yes, Honorable Deputy Minister. Oh, their hands.
I'd suggest that
Yes. I'm using a new gadget, members. Please bear with me. So it's this MacBook is quite. So I think they are hands, but let's first respond to Honorable Yako, and then.
Yeah, I want to suggest that the issue is dealt with when we come to clause 4. Basically the requirements are harmful or incite harm. So that's incitement, and it would be, I guess, an objective test for the court to determine did what was said incite harm. As far as then the partial exemptions, incitement comes again there, and that is from the incitement to harm is from Kwelane and Pepuda, but as I said, it would be the court, I think, that would determine was this incitement was this inciting harm. But you don't actually need that for hate speech. Being harmful is sufficient as long as it also promotes or propagates hatred. The second incitement is under the partial exemption, and that incitement that wording is basically from 16.2 in the Constitution. Again, it would be for the court to determine does what was said constitute incitement to cause harm. I hope that's answered, Honorable Yako. Yeah, I hope. But my main issue would be let's discuss it on the wording of clause 4 on hate speech.
Thank you.
I'm fine with that, Chair.
Thank you very much. Honorable Masanto Taylor, followed by Honorable Horn.
Thank you very much, Chair. My apology. My hand was up. I can see that Chair is not, today is not all the hands issue. Chair, I think there's something that I've missed. Unfortunately, I was busy with some disclosures here and all those things. The issue of skin color, when it was explained, is it staying here on the ground? I heard you talking about it, but I didn't get it clearly because I motivate. I think I'm off the view with the issue that it should stay. Chair?
We have done it. Honorable Chair. I think it's when.
Okay.
Thank you, Honorable Horn.
No, I'm happy.
Yes, thank you, Chair. And let me firstly say, I appreciate the sentiment and the let's say the understanding expressed by the Deputy Minister that, of course, when we deal with hate speech, it is a much more considered approach that must be followed because it is ultimately a limitation of the freedom of expression that is implemented. And I agree with him that, of course, ultimately that in dealing with that, the grounds are the one aspect that must be looked at, and then of course the wording of the substantive clause is another thing that must be looked at. Chair, I'm just again reiterating that our understanding of the guidance thus far by the Constitutional Court is that firstly, the definition that was settled on regarding hate speech was given within the context of Pepuda and the fact that that was not yet criminal hate speech. But secondly, and I think more importantly for our discussion of the grounds, I just remind everyone that the court in Kwalani ultimately made it clear that criminalization should be a last resort. And in that sense, I would think that the test would be for us to include any of the grounds that go beyond the unprotected speech that is set out in the Constitution, should be for us to consider whether Pepuda and other measures have been wholly unsuccessful in addressing unlawful speech in respect of those specific grounds, and then B, whether it as a consequence have increased or proliferated over time, given the fact that the other measures currently in place have been unsuccessful. In saying that, once again, maybe we can deal with each one of the grounds on its own, but the way we understand it is that the court in Kwalani, in inviting specifically, let's say, expert evidence, satisfied itself that in terms of sexual orientation and even HIV and AIDS status, we as a country has come to the point where those grounds needs protection. I would just suggest that we pay specific attention then to all of the grounds that go beyond the unprotected speech set out in the Constitution. Thank you.
Thank you. Are there any takers on this?
Chair, Swart, Chair.
Honorable Swart.
No, Chair, we obviously are now starting with the hate speech provisions that are far more controversial, and we've had a lot of discussions where we've put principles in the past, and now we are dealing with the specific wording. But I want to agree with Mr. Horn, but just to add one further item, and that obviously will depend on the definition of harm, which we are in agreement with, is actually at the heart of the bill when we decide on what that definition is going to be. I think it's also important for us to understand what hate speech is. And yes, we doubt whether it should be criminalized. We also have expressed our views on existing legislation being sufficient. However, when we're going through this process, one wants to pass the best bill possible constitutionally. So I think it's important just to remind us what Kwalani said about hate speech in the context of Pepuda, and understanding that this is criminalizing, which requires a much higher threshold, and which I would ask maybe the DM also to, he said he was going to discuss the Rabat principles, which is set out, and yes, that's not binding necessarily, but it will be helpful to see how we can include those principles as well. But if you read from Kwalani 103, and yes, there are other references to hate speech in Kwalani, but I think it's important to state that this is speech that goes beyond mere offensive expression. So if you are offended by something that is said, if you are called a name, for example, and yes, I exclude the K word, there's a particular hurtful connotation to that. But if you are called a name that might offend you, but does that name or does that expression or does that speech, can it be understood as extreme detestation and vilification which risks provoking discriminatory activities against that group. And I think that's what we need to remind ourselves. So as the court said, expressions that are merely hurtful, especially when understood in everyday parlance, are insufficient to constitute hate speech. Offensive speech is protected by freedom of expression. And so I think that we need to be mindful when we start this process of considering the technicalities of hate speech, that offensive speech is protected by freedom of expression. And that's why we need to apply these principles and look at these grounds. But you've got to look at it, and we will get to the offense itself, and we will then discuss what is the meaning of incite harm, what is the meaning of hatred, what are the meaning of these. And I think, Chair, but when it comes to the grounds, I think the department was indicating that they were going to suggest a shortened list. So I would like us to go through what the department was going to suggest, and then I would like to have a look at each one of these grounds again, very briefly, as to whether it justifies an inclusion under hate speech, given the fact that we are now dealing with a limitation of rights. Thank you, Chair.
Thank you. Honorable Masapa Chale.
No, Chair. I just wanted to find out from the meeting, Chair, because if we are going to say the department must direct us in terms of the list of the ground, I don't know what's going to be our work, because the department has given us their own view in terms of which grounds must be included. And as a committee, we have to decide and conclude on the matter. But of course, with the guidance of the department, the issue of the longness of the list, it will be informed by the grounds that we listed, that we feel that they are really belong to the list that would envisage that they will talk to the topic or the bill that we are doing. I think we must resist the temptation of abdicating our responsibility, Chair, to the department as we go on with this list of our grounds. Thank you very much, Chair.
Thank you, Honorable Chale. Honorable John Jeffrey.
Chair, yeah, just following on from Mr. Swart, I mean, yeah, he is talking about the components of clause 4, which we've still got to get to. And it's not just an issue of, I mean, hurt was not put in the bill. It was in Papuda. We didn't put this into the bill because we thought, as the court had said in Kwelane, that hurt was sort of too vague, and it's got to be serious stuff of harmful or incite harm and promote or propagate hatred. Yeah, I mean, that can be whether the wording of that is to be followed or not, and that's taken from Kwelane. Yes, Kwelane was looking at Papuda, but as I'd said, we do have a not existing statute, but we've got criminuria as a common law crime. But as with other common law crimes, our proposal is to Parliament to make it a statutory crime. If you remember, before the Sexual Offences Act, rape was a common law crime. But in terms of the common law definition of rape, it only involved a particular kind of penetration. It was only women who could be raped. The definition in the Criminal Law Sexual Offences Act has changed that definition and has broadened it. I think quite clearly, if one sees the anger after this comment by this person on pit bull terriers, that there's a desire and people are calling for legislation on racism. So I think there's definitely a demand from society for action. The common law crime of criminal injuria would remain, but we feel there should be a statutory crime. If you look at the grounds, you'd see we left out age, we've left out birth. These were all the areas that in the earlier discussion were of a grayer area. We've left out culture. We start with albinism, and that's basically internationally people get killed because they have albinism, and anyone who says something with an intention to be harmful or incite harm to people with albinism and propagate or promote hatred against them, that speech should be criminalized because the consequences are pretty dire. The same then applies to ethnic or social. Gender, I mean, is obvious. HIV and AIDS, it's less of a problem now, but it still could be a problem. But people were killed because of their HIV or AIDS status. And the list then goes on. So the proposal from the department, I would agree with Honorable Maseko Jele, it's for the committee to consider the proposals. But that's the basis for these grounds that the department is proposing. Given that it is limitation of freedom of speech, which is justifiable, but it needs to be for a clear purpose and clear objective. Thanks, Chair.
Thank you very much, Deputy Minister. Honorable Horn.
Yes, thank you, Chair. I wanted to just pick up and maybe if, while this is not supposed to become a two-way engagement, just maybe engage the Deputy Minister on his statements around crimen injuria. At first, I understood him to say that this bill will have the effect of abolishing the common law crime, and then later on in his input now, he indicated that crimen injuria would stay as part of the law. And I wanted to ask whether it's been considered whether that is necessarily wise if one is then to codify provisions or criminal provisions around unlawful speech. After having eaten humble pie yesterday, upon realizing that in blue, when you deal with hate crimes now, the hate speech provisions could not be the underlying crime. I later on realized that crimen injuria could then still be the underlying crime. And I don't know whether that ultimately is what the real intention is behind this piece of legislation. So I don't know whether the Deputy Minister or the department is in a position to say whether it has been considered, whether crimen injuria then still will have a place in our law if this bill is passed into law and signed into law ultimately. Thank you.
Thank you very much. Deputy Minister.
Chair, look, the bill, I'm sorry, Mr. Horn misunderstood things, but the bill has never said that if you want to repeal a common law crime, you've got to specifically say so in the legislation, and this bill has never said that. Criminal injuria is also wider than hate speech. I mean, it is in terms of the definition, it's impairing the dignity or privacy of a person. So you could have, I mean, I would be a bit concerned about repealing criminal injuria because there may be unforeseen consequences. And it would be better to see how this develops with the hate crimes, hate speech bill. But you could commit criminal injuria against somebody that isn't hate speech. So it's impairing the dignity. So Mr. Horn, you and I have had our differences on the committee. I think we've always been civil, but let's say that one of us, you or I, insults the other one. We don't refer to any of the grounds that are listed here. It's purely personal. You or I could charge the other person with criminal injuria for impairing our dignity, your or my dignity. But it's not on any of these grounds. The privacy aspect, which is part of criminal injuria, it's an or. I'm not sure where that has worked and where that has been put into practice, but it's part of the definition of criminal injuria. But basically, impairing my privacy is also, I don't think, really a hate speech issue. So my view, personal view, the officials can also add their comments, is that there are other things in criminal injuria that are not hate speech, definitely, and it wouldn't be correct to repeal it at this point. I take the point that you've raised on criminal injuria is not, it could be an underlying crime, and that's something we need to look at. Incidentally, the express removal of hate speech from hate crimes was as a result of the public submissions, but maybe that's something that we also need to look at, is whether we need to exclude criminal injuria as a underlying crime. Thanks, Chair.
Thank you very much, Deputy Minister. Honorable Swart.
Thank you, Chair. Yes, and I also understood this as not repealing criminal injuria, given the fact that criminal injuria specifically is also referred to in Papuda, where in section 21, where whilst Papuda is a civil remedy, there can be an order directing the clerk of the Equality Court to submit the matter to the Director of Public Prosecutions for possible institution of criminal procedures in terms of the common law, which would then refer to criminal injuria or relevant legislation. So that would put paid to the idea, I think, that the criminal injuria is being repealed in any way. But it obviously raises the question which we've raised, we've debated backwards and forwards, and a policy decision has now been taken to continue with hate speech, but whether it's needed at all, I'm not going to canvass that again. I still hold the view that hate speech is not necessary, but given, and I just want to add to that point, the outcry around what was said recently, justifiable, and we find those statements totally unacceptable and condemn them in the strongest possible words, but that person is being charged under criminal injuria. Now, I'd just like to ask the DM, the exemptions that would apply in terms of hate speech do not apply in terms of criminal injuria. Would you agree with that? The partial exemptions, as you referred to, I don't see how they would apply. They might, I'm not sure, but we are dealing with a statute here as well, but criminal injuria would be subject to the same constitutional protections when it comes to freedom of expression, freedom of religion, one presumes. Thank you.
Thank you very much. Honorable Maseko Jele, is your hand, is it an old hand or a new hand? Honorable Jele? I think it's an old hand. Deputy Minister?
Chair, thanks. this bill's not doing anything to criminal injuria, so those partial exemptions wouldn't apply to criminal injuria. So you could still have a situation where in proselytizing or preaching, you say things that are harmful and promote hatred towards gay or lesbian people. The partial exemption allows you to do that, but you could, the person, the minister, the person saying this could still be subject to criminal injuria, a charge of criminal injuria. I would have hoped that when we have this bill, that the NPA would use this act rather than criminal injuria on the clear-cut hate speech aspects. You know, you without raising the point too strongly, but I mean, the definition of criminal injuria is impairing the dignity of a person. It's singular, and it's not clear whether it can, and it hasn't gone to any higher court, whether it can be used when it's the dignity, when a particular person is not singled out, as in Vicky Momberg's case, but it is a group that is attacked. Is that criminal injuria? So we want to make sure with this bill that it is. It's an individual and it's a group. So and then also the issue of, I do think, and I think there's international jurisprudence on it, that with the freedom of religion aspect, that limiting the restrictions on religious proselytizing, that it may be unconstitutional to simply use the harm or inciting harm and promoting or propagating hatred for proselytizing. So again, somebody can be charged with criminal injuria for that, but the chances of, I would have thought it would probably end up in the constitutional court as to whether that is constitutional or not, the harmful and inciting harm and the promoting or propagating hatred. I don't know if that explains it.
Honorable Swart.
No, Chair, I think that is helpful to understand as we grapple with this. As we know, if we study international issues, what hate speech is often used against religious preachers, where they might speak out against homosexuality or against abortions or against those issues. But in terms of my understanding of those hate speech clauses, is there is not a freedom of religion exemption that one has here, as a partial exemption that can be buttressed maybe, and that's what we will be suggesting as well when we get there. But I just wanted to understand the issue around criminal injuria. Obviously, those partial exemptions would not apply to criminal injuria, given the fact that they only apply to the statute hate speech offense. But clearly, I suppose they can be raised as a defense, not statutorily, but as a normal defense to a criminal case. But I think there is an important distinction here which needs to be made as well. Thank you, Chair.
Thank you very much. Can we have a 5 minutes comfort break and come back at 25 to 11? Can we start? Members, just before we proceed, I've been advised that the report that must go to the House, Ms. Silkstone is working on it. It would be a pager. The request is that if possible, you can deal with it today. Maybe we can have 10 minutes to read it once they are done with it. so that we can be able to submit it today. And when we ask for permission, will that be in order, members?
Thank you.
Yes, Chair. Yes, Chairperson.
Okay, thank you very much. Now let's proceed. So we're still, in fact, we still have to deal with the grounds after that discussion, which was talking especially to a desirability for us to have hate speech and the definition. Can we now go to the grounds? Are there any takers? Honorable Horn?
Yes, Chair, I don't know to what extent the, let's say the justification document in terms of the characteristics are then doubling up as the justification document in terms of speech. So maybe the department can enlighten us about that before we then deal with each one of the characteristics. From our side, Chair, I think we have said it before, so at the risk of repeating ourselves, we are of the view that we should be very careful before deciding to extend the grounds beyond the list of unprotected speech as set out in the Constitution, and then with the additional finding or ground and grounds identified by the court in Kwalani. In saying that, of course, I'm mindful of the fact that this is already a shortened list, but nonetheless, I think we must then at least towards those grounds that go beyond that specific constitutionally protected or unprotected speech, get some feedback as to, for around their album, what is the type of speech patterns, full speech that has been identified and which then necessitates the inclusion of each one of those grounds. Once again, to my mind, only those at this stage that goes beyond the unprotected speech in the Constitution. Thank you.
Thank you, Honorable Horn. Mr. Dupree?
Thank you, Mr. Chair. Mr. Chair, I appreciate that the definition of grounds is very important. However, one should be careful. If we look at section 16.2 of the Constitution, there are 4 grounds there. Okay, they are included in the definition of grounds in this bill. But that means that that is totally unprotected speech. It does not mean that additions can be made to the list as long as they are then justified if they are challenged in terms of section 36 of the Constitution. But what I would like to point out to the committee at this stage, that apart from the grounds, and sorry, Chair, I'm interrupting myself. I'm sure that Ms. Botha would like to add to what I'm going to say now, but I would like to maybe provide you with an analytic answer to the question that was raised, and that is, apart from grounds, there are specific components associated with clause 4, and the very important definition to be read into clause 4 as well is the definition of harm. Now, the definition of harm as it was introduced, or in the introduced version of the bill, was a very wide definition, and that was now substantially, if I may use that word, restricted to point out that a person's human dignity or the targeted group must then objectively, in other words, an objective test and not their subjective feelings, must then be undermined. And then if we go to clause 4, and I'm just quickly going to jump to it, Mr. Chair, because
Mr. Dupree?
Chair, are you also experiencing interruptions? I thought it was my side.
Yes, yes, on Mr. Dupree's side.
of the bill.
Sorry, Mr. Dupree, you were interrupted. If you can be so kind, I think you were interrupted when you were saying, let's go to chapter 4. Then after that, we could not hear you.
Sorry, Chair. I see that I had an unstable connection. I apologize for that. What I wanted to say, Chair, is then just maybe to remind the committee that if we compare then the proposed amendment of subclause 1 compared to the one or the version of the subclause that was introduced, we will find that it is now a stricter test to the one that was included in the introduced version of the bill, precisely because of the fact that there is now that conjunctive. So the test will be much stronger or harsher. No, I don't want to use the word harsher. It will be a more intense test to be applied. And one should read then, of course, 4.1 together with the definitions of grounds and harm. And in that regard, I think that we, or the department is presenting a much more stricter test for someone to be found guilty of hate speech. In as far as the grounds themselves are concerned, Mr. Chair, I don't know whether Ms. Botha would like to add anything, but I would like to point out to the committee that there are, no, let me rather just stop there and maybe hand over to Ms. Botha if she wants to say something. Thank you, Chair.
Ms. Botha?
Thanks, Chair. I think that Mr. Dupree has covered some of the main points that we make in our research note too. The only other thing that I wanted to point out is that we, in our annexure, covered the characteristics, which are then also some of the grounds. And so the justifications, or rather the explanation that we give in the annexure is meant to stretch to both the characteristics and the grounds, and that's meant that is also in relation to explaining the rationale as to why those specific characteristics and grounds were chosen in relation to victim selection categories and methods to show vulnerability, sensitivity and discrimination. The only thing I wanted to add is that we do cover identification of grounds and the rationale for the selection of some of those grounds, or the selection underlying those grounds at it starts at para 3.5 of our research note 2. And we also cover the addition of analogous grounds, and we quote there also from Kwelane, which allowed there to be the addition of analogous grounds sort of beyond that which was, in terms of Kwelane, in terms of Pepuda. And like the DM has said, and like Mr. Dupree has said, analogous grounds can be added. And the court in Kwelane quoted extensively from a Canadian case called Watcott, and that spoke to the reason for hate speech. And hate speech is an effort to marginalize individuals based on their membership in a group and using expression that exposes the group to hatred. Hate speech seeks to delegitimize group members in the eye of the majority. Also, Kwelane spoke to the fact that you can add analogous grounds if it is limited, and if the targeted groups are not overly broad. And that is what we have tried to do with this shortened list, is to provide for targeted groups or characteristics. Thanks, Chair.
Thank you. Members, shouldn't we start with 4.1 before we come to the grounds and ensure whether we are able to find one another on 4.1?
That's fine, Chair.
Yes.
Thank you, Mr. Chair. So the offence of hate speech is then mainly as it was introduced. However, as a result, we have indicated to the committee of the Kwelane case that the disjunctive or between Romans 1 and 2 will now have to be replaced with an and that amounts to a stricter test to what will qualify as hate speech. I don't think I can take it further than that at the moment, Chair.
Thank you, Honorable Yako.
Thank you, Chair. You'll correct me if I'm wrong. Shouldn't we then also add where we say except for political, I don't know what the word is that comes after political, those two clauses that we added at first at the top, shouldn't we also include that except for a political speech or something like that?
Chair, no, it's not necessary to do that in clause 1 or subclause 1 because that's the substantive provision or the overarching provision. However, if we get to the subclause 2, then we deal with the exemptions to the general provision itself. So we will get to sub 2 in a moment. If there aren't any other questions around subclause 1A, Chair.
Thank you. Ms. Botha. Can I allow Ms. Botha and then Honorable Horn and then Honorable Swart?
Thank you, Chair. I just wanted to, in response to the question about whether we ought to exclude political affiliation or conviction and trade and occupation, that the definition you'll see here in 4.1a that we mention based on one or more of the following grounds. And if we read that together with the definition of grounds, it is automatically excluded. So there's no reason to, in this clause, exclude it because in the definition of grounds, it is not there. Thank you.
Thank you very much, Honorable Horn.
Yes, thank you, Chair. I wanted to hear from the department. If one reads Kwelane, it ultimately, and now I must choose my words carefully, because we of course subscribe to the rule of law. But my reading of Kwelane is that the court was not quite clear about the concept of harmful. As it is, it dealt with different submissions. Some of them ultimately talking about the fact that for something to be harmful, there must be physical harm, others talking about severe psychological impact. and then ultimately, the court did say there must be a distinction between something being hurtful, or I think another term for that could be offensive and harmful. But my reading, unless I didn't read it with full understanding, was that the what is deemed to be harmful has not really been dealt with finality. The Human Rights Commission similarly talked about deep psychological and emotional harm being caused, etc. So I don't know in terms of, let's say, specifically when one wants to establish a criminal offense, what the impact ultimately of that would then be. And we know there is a definition of harm, but not necessarily of harmful. So firstly, before maybe having a follow-up question or suggestion, I would maybe want to hear from the department what their view is on what I see to be some remaining uncertainty about that specific concept. Thank you, Chair.
Thank you, Honorable Swaraj.
Yes, Chair, we spent quite a bit of time on various options on the definition of harm. And I think as we're going forward, it would depend on what option we follow as well, will determine the degree how we understand harm. And I think we had a debate around the broad terms of economic, social, and cultural. And I think there were some concerns expressed about the terms social and cultural. I've expressed concerns about that, those broad terms. I think we asked for definitions that can come in at some stage, but I think those are very, very broad concepts. I think the concern that, and that's why we then added some the definition of harm, as Mr. du Preez referred to with an excellent pun, substantially changed the definition by inserting the word substantial and severely, I think. So we'll be looking at that definition as well, but I think it will be good to just answer Mr. Horn in that regard, because it is the essence. I think we would also need to then look at what do we understand the concept of hatred. And then, of course, I do appreciate my reading of section 16.2, and that constitutes incitement to cause harm, the advocacy of hatred, and the cause of harm. I always understood it to be physical harm, but I do appreciate that the courts have now said it is much broader than that as well. But that should be a starting point as well. So I think there's a lot, and I think this is helpful that we are engaging on this, because this is the substantive part of the hate speech clause. I would specifically then also like to just ask, the concept of hatred is also a very broad term. Most people understand what it is, but I suppose and I presume that would be objectively determined by a court. What do they understand by that concept of hatred? Because I think we need to spend some time on that as well. Beauty is in the eyes of the beholder, and what one person might see as something that is motivated by hatred could be motivated by something else. So I think we need to spend some time on that concept as well. Thank you, Chair.
Thank you, Honorable Swartz. Some would say beauty is in the eyes of the beholder. Honorable John Jeffrey.
Thanks, Chair. No, just, I mean, dictionary definitions: hatred, intense dislike or hate. There's references to extreme dislike or disgust. But I do think in terms of what is meant by hate in hate speech, I would have thought that there's international definitions, because this is an international concept that are continuously developing as different courts across the world interpret them. But the term is hate speech, so that's used in many countries. On the issue of harm, the court in Kwelane gave different versions. Hurt was taken out as being vague and possibly duplicating with harm. And we then got the definition of harm that people had looked at and made suggestions on in the definition section. Just in terms of harmful, I mean, the dictionary definition of harmful is causing or likely to cause harm. So if we're defining harm, then I think we are clearly defining harmful too. So I just wanted to add those points, Chair. Thanks.
Thank you very much, Honorable Horn. Is that clear now? Honorable Horn?
Sorry, my apologies, Chair. I was speaking to myself, and I will not say that it is because of old age. Chair, no, look, I don't want to be difficult about this. To my mind, I think it's important to make clear, to have clear provisions. And the interesting part is that if one goes then with this dictionary version of be harmful, it would seem that it is sort of a duplication then, or just a repeat to say be harmful or to incite harm. And that remains the difficulty. Whether that ultimately will lead to prosecutorial issues, I'm not quite sure. I would want to consider it a bit further, and maybe also ask the department to now use the words of the Deputy Minister. What would be the harm to then just stick with to incite harm only, if harmful really is also just indicating that it has the potential to cause harm? Thanks.
Thank you very much, Deputy Minister.
Yeah, I think there's a clear difference between those. I mean, the key issue is incitement. And where Kwelane was important was that being harmful can be sufficient on its own. So I don't think there was any allegation that Kwelane in his opinion piece was inciting harm. He was just being incredibly harmful about gay people, gay and lesbian people. So the two are different concepts. The one is to be incredibly harmful, incredibly deeply nasty, deeply causing. I can't remember our definition. The other thing is incitement. But we do need a. I mean, Ms. I can't remember her name. Belinda. Of the pit bulls. Was she inciting harm? Maybe in terms of black women cutting out their womb, having to have their wombs cut out, etc. But I mean, it was deeply harmful. So I think it, and I don't know why. I mean, you know, the Constitutional Court, in terms of Papuda, has said that phrase is constitutionally acceptable for Papuda. Yes, Papuda is civil, but as a definition of hate speech, why can't it be used to as elements of hate speech? Why change things? The harm issue is also, people have raised with me, or why is it not physical harm? But the Constitution doesn't limit it to physical harm. So I think that argument is a non-starter. And using the K word may not be inciting harm, but it's harmful.
So can we have this one, this section 4.1 as it is, as option 1, and something to what Honorable Horn and supported by Honorable Swart raised as option 2, so that when we come back, we can be able to decide as to which one is much more appropriate. Is that in order?
Mr. Chair, will you allow me just 1 minute, please? I think I know what Mr. Horn's concern is, and it's not going to take too much to maybe give you an indication at this stage how option 2 will look like. So please bear with me.
Okay.
Come on.
Chair, while Mr. Dupré is getting ready to speak, may I just raise something? And I accept that we must go back and come and provide some information on this clause. May I speak, Chair?
Proceed.
I think just by way of reason why the word harmful should not be left out, when one looks at the ordinary meaning of what hate speech and how it is defined in other dictionaries, there's an element of harm that will be left out if we do not, there's a critical element of hate speech that will be excluded if we leave out the word harm, in the sense that they say that hate speech is public speech that expresses hate or encourages violence towards a person or group based on something such as race, religion, sex, or sexual orientation. And then I think the next sentence is important. Hate speech, and this is the ordinary meaning of it because we can take it from the dictionaries or one of the ordinary meanings. Hate speech is usually thought to include communications of animosity or disparagement of an individual or a group on account of the characteristics. So I think when you look at those communications of animosity or disparagement, those are the elements that give rise to the hatred and the harm that we are talking about. So I think that I'm not expressing it as well as we should, but I think it'll be very very bad for the bill if we do not include that concept of harm and leave it to just incitement.
Thank you very much, DDJ Pillay.
Swart, yeah?
Ms. Botha?
Swart, Chair.
Okay, you are noted.
Thank you.
Chair, notes me also.
Yes, I've noted.
Chair, can I proceed?
Yes, proceed.
Thank you. I just have had a look at Kwelane again, and I've noted that at para 154 of that judgment that the court speaks quite extensively about the definition of harmful and what it is, or what it entails rather. And the court took issue with not the word harmful in Papuda, but the word hurtful. And that hurtful was vague and unconstitutional. But the court in Kulane, para 154 said, in contradistinction to the insuperable difficulties hurtful, the term harmful does not suffer the same fate. I mean, on a plain reading, harmful can be understood to be deep emotional and psychological harm that severely undermines the dignity of the target group. They quote a Canadian case from the Supreme Court of Canada, and they speak to the types of harm, that there are 3 types of harm, and also the 2 sort of overarching types of harm, is harm done to members of the target group and harm done to society at large. So the court in Kulane did, to my mind, express itself quite clearly on the definition of harmful. Thanks, Chair.
Thank you very much. Honorable Maseko Chele, followed by Honorable Swart.
Thank you very much, Chair. Chair, can Mr. Dupreez bring this down a bit so that I'm able to see 1 and 2. Chair, I think it will be a mistake if we leave harmful, Chair. Because if you go to the dictionary, I think I concur with the DD with what he has just said now. I went through this harmful and harm on the dictionary looking, Chair, and I realized that it even covers incite, to incite, the incitement as a word on itself, Chair. So if we are going to limit, I mean to say, take the harmful out here, Chair, and say only cause or incite harm, to me, it's not going to serve the purpose of what we are trying to do here, Chair. But I'll leave it to the options that we are coming with. I support the first option. Thank you, Chair.
Thank you. I think it is harmful to demote DDGPLA to BDD.
Okay.
No, thank you very much, Honorable Swart.
Chair, I appreciate that we've taken a lot of our guidance from the Kulane judgment, and I have referred to it extensively. We need to bear in mind, however, that that was a civil judgment, and we are dealing with a criminal sanctions here and a criminal offense. So I am just looking at this, and it's for debating purposes and for discussion purposes. But if you look at 16.2, and obviously one is not limited to section 2, but these are the acceptable, I hesitate, exclusions under freedom of expression, 16.2. Now, if you flip it around, you would need to say that any statement or publish or propagates or promotes hatred based on the grounds and that constitutes incitement to cause harm. That would probably be section 16.2. You would need an and as section 16.2 adds. And that's why some meetings back I asked the DM about the issue of incitement. And that and is very significant in 16.2. And I need clarity. Yes, we are guided by Kulane, which has flipped it around to say be harmful or incite harm and promotes or propagates hatred. So the issue relates to those 2 words that Mr. Horn has now raised, be harmful, which adds an additional element to the exemptions of 16.2, which I understand would relate to incitement to do harm and promote or propagate hatred. I might be wrong, and I think the question is there a limit then to the usage of the words be harmful as it has been referred to in Kwelane from a constitutional perspective, but bearing in mind Kwelane refers to Papuda, which is mainly civil, but there is a criminal element to that as well. Thank you, Chair.
Thank you very much, Honorable Horn. Firstly, does this option 2 take all your concerns into consideration?
Yes, I think that is what I was thinking of, Chair. I think I'm largely covered by the input of Mr. Swart on this issue. And just to say, and I understand that this could be a point of divergence within the committee, but to my mind, for us to ultimately pass a criminal offense in respect of hate speech, we can't say that we are necessarily married to the definition within the Papuda context given to us by Kwelane. So I strongly agree with the Honourable Swart. I think we as a committee must wrestle with whether it could be justifiable to say that we just duplicate whatever we found in the context of Papuda when we do criminalize hate speech, because obviously criminalization is that one step further. I keep on reminding everyone that Kwelane itself said that it's a measure of last resort, other measures having failed. And in that sense, I do believe I would be thankful if option 2 at least stays on the table. Thank you, Chair.
Thank you very much, Deputy Minister.
Thanks, Chair. The Constitution at 16.2 outlines what is not protected, which is not protected under freedom of expression at all. And that is basically propaganda for war, incitement of imminent violence, or, and this is the important one, advocacy of hatred that's based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. So that's what is not free speech. What Kwelane did was to say under the limitations clause, you can go wider than that definition. And that's what they did with this issue of, one, they extended it to homophobia, which isn't one of the grounds listed in 16.2c. And then 2, they said harmful or incite harm and promote or propagate hatred. So it's through the limitation clause effectively that we are arguing this bill and these limitations. We need to look at what we want to do. Should it be criminalized to use the K word, to call somebody with the K word? Yes, it should be. It's hurtful, it's harmful. Is that covered under 16.2c? No, I don't think it is, because calling somebody with the K word is deeply obnoxious and harmful. But does it constitute incitement to cause harm? Are you inciting people to cause harm? I would say no, you're not. Penny Sparrow, what she said was harmful, but she wasn't inciting people to commit harm. So I think that Kwelane was important in that the word incitement is not necessary, or it's not a requirement rather. And that's why in the definition, if you have the alternatives in the definition, it's harmful and promotes hatred or propagates hatred. That's sufficient. You don't have to have incitement is not a requirement for hate speech. And I think that's important because there is speech that is made that does not necessarily constitute incitement to cause harm, but is deeply obnoxious, and people would agree, I think society would agree, people who say those things or communicate those things should be subject to criminal sanction. Thanks, Chair.
No, thank you very much. I think we have spent a lot of time on this definition, and there are two options. I think that covers broadly our stances on this issue. Both option 1 and option 2, I think they've been adequately motivated. We will come back to this issue later, whether we move with option 1 or with option 2. Can we move to the next one?
Thank you, Mr. Chair. Subclause 2 then deals with those exemptions, if we may call it that, to the provision or the provisions of subclause 1. And that refers to bona fide artistic creativity, then academic or scientific inquiry, and then fair and accurate reporting or commentary in the public interest. And then D, the interpretation then of religious beliefs, etc. Now, Mr. Chair, the department has now submitted a proposal to the committee. Sorry, Chair, I see there's a hand raised.
Sorry, it's premature. Sorry to interrupt. I'll wait, Chair. I'll wait.
Yeah, I know you're noted. Proceed, Mr. Dupree.
Thank you, Mr. Chair. The proposal from the department side at this stage, Mr. Chair, is that the provisions of subsection 1 do not apply in respect of anything done as contemplated in subsection 1. If it is done in good faith, in the course of engagement, in any bona fide, and then they are listed: artistic creativity, academic inquiry, fair and accurate reporting, in the public interest, or publication of any information, commentary, advertisement, or notice. And then the interpretation then of the religious grounds. That does not then, if it does not advocate hatred that constitutes incitement to cause harm based on one or more of the grounds. What I would like to point out to the committee with regard to the proposal in as much as subparagraph C is concerned, if I may quickly go back to the previous C, you will note that the word commentary is used in the context of in the public interest. However, if we look at the Constitution, Mr. Chair, and that is what I would like to point out to you, is that or let me rather put it in a different way for you. The artistic creativity is then covered. Sorry, Chair, I'm struggling to read my Constitution this morning. I apologize. However, we've got 4 grounds in subsection in section 16(1) of the Constitution. It's freedom of the press and media, and then freedom to receive or impart information or ideas, then artistic creativity and academic freedom. Now, with regard to paragraph C, the first part of that proposed paragraph now relates only to fair and accurate reporting in the public interest. Now that is press freedom, Mr. Chair. If we look at the second part of paragraph C, then we actually refer to the notion of section 16(1)(b) of the Constitution, and that's the freedom to receive or impart information or ideas. So strictly speaking, there are 2 components in paragraph C, which should then actually be separate from each other, first of all, because D, my apologies, will then most probably become subparagraph E. So I don't know, maybe we can I think I maybe should pause here, Mr. Chair, for questions.
We had Mr. Honorable Swart. Or maybe let's start with Ms. Botha. Maybe she will just complete your train of thought. And then we have Honorable Swart and then Honorable Jelle.
Thank you, Chair. I just wanted to point out that potentially I might have missed it, but I think we skipped over discussing 4.1b. So it's just to note that we would need to come back to that. Thank you.
Where is that?
It is clause 4.1b, Mr. Chair. There are 4.1a deals with hate speech, intentionally publishes, propagates, advocates, or communicates anything. And then B relates more to electronic communications on your social media platforms.
Okay. Honorable Swart.
Chair, I would like to suggest a tightening up of the religious exemption as per my submission in 2019 as an option, and maybe I can do that and it's just a few words to insert under D, and that would be an option which would be the insertion of the word conviction after religious in the first sentence, and then after the word doctrine or writing, it will be by a religious organization or an individual in public or in private. That would be my proposal as a sorry, no, it's not. I think it's under the religious of any religious conviction, tenet, doctrine, or writing, and then after the word writings, to insert the word by a religious organization or an individual after the word writings, by a religious organization or an individual in public or in private. This has been a suggestion by a number of religious organizations, including FORSA in particular. And the question is whether this, the word proselytizing, and it's belts and braces basically, because proselytizing can mean individual, can mean an organization in public or in private. So it's more a belts and braces to my approach, but it's something as an option to consider. Thank you, Chair.
Thank you. It would be option 2. Honorable Jelle.
Thank you very much, Chairperson. I think mine is on A, Chair. My comment is that on artistic creativity, performance, or expression, this one, Chair, I want the department to just clarify something here. These things, Chair, have been left for a long time for people to say or do things that hurt people and not attended to. I'm going to take it to the extreme. The department will assist me. That artistic creativity. What do we say in a situation, Chair, where previously I gave a definition of the word black, and where the artist decide to come with a picture or a creature. For example, I did say, Chair,
when you click on Google, wanting to find out what is the meaning of black, the artist decided to give a very ugly picture there, Chair, that depicts black. So it might not be that one. How, and many more, Chair, how are we going to differentiate that this was done bona fide or was done intentionally when it comes to that, Chair? Because already we have information outside there that talks to this, Chair. The issue of the freedom of art or artistic creativity, if I may say, Chair. So I would like the department maybe to comment on that one, because it really disturbs a bit, Chair. Thank you.
Thank you, Honorable Swart.
Now, Chair, just to ask an option, remove the word doctrine, which is in blue, because that word is already there. Thank you.
Thank you very much. The department, can you respond to Honorable Maseko Jele?
Thank you, Mr. Chair. Mr. Chair, the whole issue of whether a person engages in bona fide artistic creativity and in good faith, then of course, is a question that, and I know it always sounds as if we want to sidestep the question, but it's up to the courts to decide within the facts of each and every case, Mr. Chair, whether something will qualify as bona fide artistic creativity or not. Now that is unfortunately the short response, Mr. Chair. You know, I like to be, or try to be brief in the committee. Thank you, Chair.
Thank you very much. Deputy Minister, I think your hand is up.
Yeah, thanks. Sorry, I put on the camera before I raised my hand. Look, we've got to be careful of. We do have freedom of expression. So this is a partial exemption, which basically goes back effectively to 16.2 and what is not free speech. So we're not using Kwelane and the limitations clause to go wider. It is a balancing act. There are people who get very offended by some artistic creativity or performance or expression. There's the issue of the painting The Spear of the former president. That I don't think, though, falls into hate speech because it wasn't linked to his involvement with any group. Probably he could have argued for criminal injuria, impairment of dignity. But it's issues of where do we draw the line. There was one quite interesting Equality Court case which went, I think, on appeal to the High Court. And that was a person who wore a T-shirt which had the slogan, and let me spell it out so I don't get accused of Chair of offending anyone, but it was F***CK, white people. And somebody objected to that and took them to the Equality Court. Now, the Equality Court, and it was the High Court judgment, found that, look, this slogan was it was offensive to some people, but it was as part of an art exhibition. It was in a particular context. So the Equality Court found in that context, it wasn't hate speech. Obviously, as I said, some people would be offended by it, but we're not trying to sanitize the arts, creative expression, that kind of thing. Maybe just one issue to Mr. Swart on his option 2. This is only about crimes for a natural person, not by a juristic person. So I'm not sure if the point of having a religious organization, because some individual has put that out. If you hear the maybe I get, I think what you're trying to do, but trying to say, but yeah, just a religious organization cannot be prosecuted, or any organization can't be prosecuted in terms of this act. Bill, sorry. Thanks, Chair.
Thank you very much. Can we now go back to the grounds? I think we do now have an understanding of the foregrounding of the grounds. Can we now go back to the grounds? DDG Pillay.
Chair, my apologies. Shouldn't we?
Sorry, Chair. I just. I'm sorry, Chair. I just want to make a very brief point, and just to point to some examples.
DDG Pillay, are you on the grounds, or are you still on where we were?
No. If I don't need to say. Yes, Chair, I just wanted to say something about artistic creativity and the kind of controversies it has raised throughout the world. But I think the Deputy Minister has covered the issue, but just to point out a few examples of how controversial it is. But if you want to go to the grounds, I'm happy with that. I can hold back that comment. Thank you, Chair.
Can you conclude your matter? Can you conclude? Can you speak about those controversies?
Can I go ahead?
Yes.
Chairperson, this whole issue of freedom of expression and the artistic creativity that we want to that we protect in our constitution, and as it's protected in other parts of the world. However, it's a subject of a lot of debate, and it has caused a lot of controversies, and it has caused quite a lot of protests and harm. And I just want to mention two examples. One is of the Danish cartoons that were published in the newspapers relating to Islam, and the worldwide condemnation that came after that. And then also the ban on the book Satanic Verses as well. So I think it is a very controversial issue, but so there's this division between what the Western world thinks of as protection of freedom of expression, and what, for instance, a Muslim world would feel when aspects of its religion comes under attack. So, and I think that we know about the incidents and all of that flowed from that kind of controversy. So it's a very deep and controversial issue, which can lead to serious violence and protests, etc., and also on what our concept of freedom of expression is, and how we deal with issues such as religious matters, etc. So I just wanted to raise that. If you want me to talk more about those incidents, I could, but I think it's all well known in terms of that matter. Thank you, Chairperson.
So what are you suggesting?
Chairperson, I think I will stick with what the Deputy Minister has said, but I just want to raise that it is a matter of controversy and something that that has been considered, but the freedom of expression has always trumped the rights of those kind of objections that have been raised to freedom of expression when in artistic creativity. Thank you, Chair.
Thank you. Can we move back to the grounds? Honorable Chair, is it an old hand or a new hand?
It was new, Chair, but I was really impressed by the last comment because it really talks to the sensitivity on this matter, Chair, like I indicated earlier. Thank you very much, Chair, for that.
Thank you, Honorable Deputy Minister. I think I heard you wanted to speak at some point.
Chair, no, I'm fine. Well, maybe just to go onto the grounds. Can I do that?
Yeah, no, let's go to the grounds.
Chair, my apologies, it's Daniel Ron speaking. We, as Ms. Botha has pointed out, did not deal with 4.1b. I don't know whether we possibly should do that before we then return to the grounds.
4.1b, let's just, sorry, Deputy Minister.
Thank you, Mr. Chair. So yes, this is primarily then information that is distributed on electronic communication networks where you have all the social media platforms that are being used to spread this type of speech then. I recall the committee has gone through this on a few occasions. I don't know whether I need to say much more at this stage, Mr. Chair. Maybe I could leave it open for questions or comments.
Yes, Honorable Horn, don't you think that maybe we might need to go back to the grounds and then we can come back to this one? Because I just wanted a foregrounding for the grounds before we talk about them. I'm not sure whether does this one still has any relationship to the grounds, or is the means of communicating?
Yeah, no, I'm fine with your approach, Chair. It doesn't need to be dealt with now. It at best is, of course, secondary to the grounds. Thanks.
Thank you very much. Honorable Jelly, is it a new hand or an old hand?
It's a new hand, Chair. I also wanted to make a comment. We really dealt with this matter extensively. I remember there was the issue of social media also when we were dealing with it. My worry is that, Chair, we will be...
Sorry, okay. Sorry, Honorable Chair. I think we have agreed that we are going to come back to it after we have dealt with the grounds. Then I think those arguments, I think just reserve them. And then when we come, after we have dealt with the grounds, then we'll come back to it.
Yeah, okay, Chair, I agree. That was my worry coming back, because, Chair, it means if I'm not in and then you deal with something, because DA was covered also here, because the comments that we got, it was from them, but I understand, Chair. So we'll be delayed if we do that next time. Thank you, Chair.
Thank you very much. Now let's just go back to the grounds. These are the grounds. Honorable Deputy Minister, do you want to speak on the grounds?
Yeah, just the 16.2 has four of those grounds: race, ethnicity, gender, or religion. So what we've added is albinism. It's added because people with albinism are very vulnerable, and if there are people who say things that are harmful or propagate hatred against people with albinism, it could be fatal. So that's why we've put it there. Also, we don't think that a restriction on albinism as hate speech or the ground of albinism for hate speech is that restrictive for freedom of speech. Then we've added social origin to ethnic. But ethnic, I think, would be beyond dispute. Gender is in the Constitution, is in section 16.2. HIV and AIDS is there because, again, and it's less so now, but it can still happen, that if you say something that is harmful and promotes hatred against an HIV positive person, it could end up badly for them, and it has ended up badly for them. Then we've included, which wasn't there, nationality, migrant or refugee status or asylum seekers. And Chair, this is basically to deal with xenophobic utterances, particularly, that people can say things about migrants, refugees or asylum seekers that are harmful, that promote hatred, which can then create, well, again, end up in violence to those people. Then race, religion are in the Constitution. Sex, we've added because we have a serious problem of gender-based violence against women, or violence against women particularly. And anything said that promotes violence against women is something that we feel there is a justification for restricting. Then Kwelane added sexual orientation. So that's from Kwelane, that it was permissible to extend the ground. We've included gender identity or expression or sex characteristics. Chair, we have a problem of well, it's been there for some time, but it's come up more of bullying in the schools. And certain children have committed suicide because of that. And that's been on the basis of their sexual orientation or their gender identity or expression particularly. So again, we think there's a motivation, a justification for limiting or including that under hate speech. And then lastly, a skin color, which you'd wanted included. But remember, so those are the limitations on free speech, and what you say then has to be harmful. I mean, the definition that we've gone through, harmful or incite harm, promote or propagate, and promote or propagate hatred. But I think I'd also urge that we look at, when we look at these categories, we look at what we're trying to prevent. Thanks, Chair.
Thank you very much. Members, I would suggest that as we discuss this issue of grounds, first of all, I think there is need for grounds. As we discuss whether this ground must go or must not come in, I think members should also be giving us some direction in terms of an option, so that if we don't take these grounds as they are, we would want others to be taken out and others to be added, create those various options so that we can see where we stand and we can be able to move forward. So I think we must not just end at just criticizing a ground, provide an option that we must take. Any takers?
My hand is up, Chair.
Honorable Jala.
Thank you very much, Chair. In line with the extensive debate that we had on the characteristics, Chair, I think for me, we have a direction as to which wants to confirm and say these are supposed to be the grounds, because we did have a long discussion about this, Chair. I agree with all of them as they are, Chair. And also, but this or on the skin color, Chair, I would request that it be removed. It should be skin color, as we said, skin color. It shouldn't be sexual orientation, gender identity, or expression of sex, character, or skin color. This has always been like this. The issue of skin color was standalone. It was not all. So can I request that this all be moved away, Chair. And then we have skin color like we have it there. Thank you, Chair.
Mr. Chair, may I respond immediately?
Okay.
Chair, paragraphs A to I to J must be read disjunctively. And there's an or at the end of I, just to emphasize that these paragraphs must be read disjunctively. Skin color does stand on its own. I appreciate that it might not look like that on the screen itself, but it is a self-standing reference to skin color then. Thank you, Chair.
Thank you very much.
No, thank you, Chair.
Chair, maybe just to add, I mean, the or was previously, the or would be always at the second last ground. So previously it was after sex. It now moves down because skin color is the last ground. So just to follow that up, and it's one of these things, not all of them.
Okay. Thank you very much, Honorable Horn.
Yes, Chair, firstly, maybe in response to your request for options, I don't think we in respect of this shortened list are necessarily there, apart from, unfortunately, and with the greatest of respect to the Honorable Maseko Jele, saying that we are not necessarily convinced that either the vulnerability or the incidences of specifically hate speech aimed at people who, on the basis of their skin color, justifies criminalization of that speech at this stage. In respect of the rest of the list, I think, as the Honourable Deputy Minister has indicated, I think there's a very good case to be made out that if speech is not protected under the free speech provisions of the Constitution, then to pass the hurdle in order to justifiably criminalize those speeches, of course, a much lower hurdle. In terms of albinism, I agree with the Deputy Minister that the resultant limitation is fairly small, and that the group is clearly defined, and therefore the vulnerability, I think, can be easily discernible. Chair, in respect of sex, of course, we hear the justification around gender-based violence in South Africa. And whilst, of course, we are, as members of Parliament, and hopefully also right-thinking South Africans, we're fully committed to end the scourge of gender-based violence. I'm, however, not necessarily convinced that the scourge of gender-based violence is as the result of frequent incidences of speech aimed at specifically women. But if the Deputy Minister or the department can maybe substantiate that a bit further, one can consider that. So that's our, I want to say, our response to your request specifically as to identifying grounds, and maybe just to substantiate our stance a bit further. Thank you.
Thank you very much, Honorable Horn. I don't see any hands.
Sorry, Chair. I'm struggling a bit this side. Swart, yeah.
Honorable Swart.
No, Chair, I also want to say at the outset, whilst we've had a discussion on characteristics for the purposes of hate crimes, we are now dealing with grounds for hate speech, which is totally different, given the issues around hate speech and the fact that it is a limitation on freedom of expression. I just wanted to ask whether it is justifiable to include social origin. I can understand ethnicity. Gender is correct. I can understand those issues. I also wanted to understand sex. I didn't quite understand the need for sex. If you have gender, then surely that covers gender-based violence. I can understand the extension under Papuda of sexual orientation, and that is something we need to consider. I'm not so sure about gender identity or expression or sex characteristics. I would need a bit more of a motivation for that, because I would probably think of proposing an option to only have sexual orientation under I, but maybe it could be argued it's not broad enough. But I do want to emphasize that all will depend on the very welcome and the religious freedom, or the partial religious exemption that has come a long way and over many years of discussions, how effective that would be in protecting freedom of expression under certain circumstances. I think the concern here, and that is why that's why that partial exemption is inserted, and the Deputy Minister has met with religious organizations even prior to the bill coming to Parliament, is that hate speech legislation, in particularly in the USA, in Europe, has become so problematic that even mainstream Christian beliefs and values expressed publicly and privately have in certain circumstances led to arrest and prosecution, fines, imprisonment, loss of employment. So, but in those circumstances, as I understand it, hate speech, there is no partial. Yeah. So, Chair, I just wanted my option there without debating it would be, and I'm just still considering the issue of the additional words after sexual orientation. Thank you, Chair.
Okay. Maybe we can have 3 options to cover Honorable Swart. In fact, Honorable Horn, who does not want skin color and sex. And then we have option 3 to cover Honorable Swart on sexual orientation. I think you had all others and the issues that he has raised, but they wanted a further explanation on sexual orientation, on sex. I think those were the, or also on, what was it, social origin. Honorable Deputy Minister.
Chair, thanks. Just responding to Honorable Horn and Honorable Swart. Social origin, okay. Section 9 of the Constitution, the Equality Clause, refers to ethnic or social origin as a ground for discrimination. The Section 16(2) just has ethnicity. So the issue basically is that do we need to protect people? So clearly we protect people from hate speech on the basis of their ethnicity. The question we need to be asking ourselves is, do we protect people against hate speech on the basis of their social origin? That's the question we've got to ask. I'm not really going to answer it. On the issue then of, I think the other question was, okay, sexual orientation, gender identity or expression or sex character. No, sorry, before that, sex. There's obviously a difference between sex and gender. That's why it's listed as a ground for discrimination. Again, the question is going to be, there's gender-based violence. Okay, that's based on gender, but there's violence against women. Is that violence because they're biologically women, the female sex? And I would think, yes, it is. And there's misogyny, and there's references that men will make when they speak, often to each other, about seeing women as biological sex objects, which can encourage rape. So those would be some of the issues to look at as for the inclusion of sex. But I mean, needing to distinguish between sex and gender, which is how you perceive yourself. But I think that the violence against women is it's against females. It's on the basis of their sex as well as their gender. On the issue, Mr. Swart's point of let's start at the back. Sex characteristics, that is regarding intersex people born, and there's a variety of forms of it. It can be biologically with elements of both sex organs, male and female. It can be issues of the chromosomes, etc. And Mr. Swart, I'd argue those people are vulnerable, very vulnerable from physical violence, from being harmed, and need to be protected. Sex characteristics has overtaken the term intersex. That's why intersex is deleted. On the issue of gender identity, which would be more people who are of one sex but identify with the other gender. So a person born male, but who actually identifies as being a woman. Those people are also very vulnerable. Gender expression, as I understand it, and this may not be correct, and I don't know if Honorable Yako is still on the platform, and maybe she can also assist, but it would be people who the person is a man, but likes expressing themselves as a woman. Again, because it's seen as odd, because it's seen as unusual, they could be subject to violence from some people in society. So that would be the justification for those aspects. Thanks, Chair.
Thank you very much, dear. Honorable Jela.
Thank you very much, Chairperson. Chair, I think it is important that social origin must stay. The example that I'm going to give, Chair, there is this notion of saying, if you come from the township, in fact, it also goes with the color. People who are known that they are coming from the township and Black, when they are seen in the suburbs, the only thought that comes to other people is that they are there as thieves and they must be attacked because they are coming they're about to commit crime or do something harmful to that community. And bad words are said about such people. The places where we come from, Chair, socially, they are sometimes being given stigma. And there are things that are said very harmful about our social origin, where we come from. Many of them, Chair, they are really hurtful. They are really, they inflict pain to people. And the words that are said, they are really not good, Chair. That's what I can say on that issue. We might not be able to give extensive because we never thought that maybe we'll come to this point. We should have made more research on this so that we can convincingly put an argument on this. On the issue of sex, Chair, I think, and gender, the issue of gender, it is not only women. Sometimes things are said to them. I think it also goes with gender. It can also relate to sexual orientation, though they are different. But there are some things that are said to a certain type, a certain category of gender that are really hurtful. Sex, it's us, Chair. It's women. And most of the people who are speaking words which are really hurtful, Chair, without discrimination or talking bad, are men who always call us with words that we really, if you don't agree with them, they will tell you how a bitch you are, how you are. I don't even want to call other words. So that must stay, Chair. It covers us. Thank you very much as women.
Thank you very much. I think the three categories covers the discussions we have had. We have the first category that was articulated by Honorable Deputy Minister, which is the list as it stands now. Then the second category was by Honorable Horn, which excludes social origin, sex, and skin color. And then we have the third category, which was articulated by Honorable Swart. So those are the three options that we would have under the grounds. I think let's move. If there are no further comments, let's move to the next one.
Thank you, Mr. Chair. I just need some guidance from you. I think we are finished with clause 1, if I remember correctly. All the other definitions were considered by the committee. So that brings us to the objects clause, which we have also pointed out to the committee on a number of occasions. There were no, if I remember correctly, any suggestions or objections with regard to the wording of the objects of the Act. This is merely to actually summarize the content of the Act itself. Then with regard to clause 3, we have proposed amendments in subclause 1. That was the subclause as introduced. And then the department has submitted a proposal to the committee, maybe just the streamlining of the original sub 1 as it was introduced. There's no additional provisions included in the proposed new sub 1. It's merely, as I said, a rewriting of that long clause. I don't know whether I should pause here, Mr. Chair.
I see no hands. Maybe you can proceed.
Mr. Chair, just maybe to my own detriment as a drafter, in sub 1A, we exclude, yes. We exclude the offence referred to in section 4.1. However, the question was raised, and I think the deputy gave us guidance that we need to look at whether reference to criminal injuria should also be included at the tail end of paragraph 8 to exclude it as a hate crime. if I may just get some guidance from in that regard, please.
Members, should we exclude criminal injury as part of the hate crime, Honorable Horn?
Chair, maybe if I, sorry, Mr. Horn, maybe if I can just come in. What we are wanting, sorry, is not really looking for a decision around excluding it now or not, but to say it's a valid point and we need to look at it.
Okay.
I don't know, Mr. Horn, if that covers you.
Honorable Horn.
Yeah, Chair, for once, the Deputy Minister and I am on the same page. I was also of the view that we asked a question, but I think it would only be fair for the department to consider all relevant aspects to such a decision or proposal. So I would be thankful if the department can give it some considered thought and come back to us. Thank you.
9 out of 10, you're always on the same page, but that 1% is always intense. But most of the
yeah, it's because the Deputy Minister is hurt so easily.
No, let's proceed.
Thank you, Chair. So then, with regard to the subclause 2 as introduced, any person who commits a hate crime is guilty of an offence and liable on conviction to a sentence as contemplated in section 6.1. We have also explained the proposal to the committee, and the department feels fairly strongly that the committee should consider adopting the proposal, because we have explained to the committee why it is necessary for a criminal record to reflect the underlying offence as a hate crime. Thank you, Chair. I see there's a hand.
Honorable Chair.
Thank you very much, Chair. Can we go to 6.1 and remind ourselves? I don't remember now where I am. 6.1, Mr. Dupree.
Thank you, Chair. 6.1 then deals with the penalties to be imposed under certain circumstances with regard to a person who was convicted of an underlying offence as a hate crime. And then sub 2 then refers to aggravating circumstances. If I may go back to clause 3, Chair.
Are we going to come back to that 6 and work on it later? Thank you, Chair.
Yes, thank you, Chair. Mr. Chair, that actually takes care of clause 3. The committee has now extensively this morning already discussed 4.1a. The department will then present with its next working document the options here. They are actually, I think they'll just be repeated in the next version of the working document. Then paragraph B of subclause 1 is then, of course, the electronic communication issue. And then subclause 2 then deals with the exemptions. And the department proposes that it might be.
Sorry, Honorable Chair, is that a new hand or an old hand?
Old hand, Chair. Thank you.
Thank you.
Thank you, Chair. Then this has now been discussed extensively this morning. I don't know whether you want me to highlight anything, and I don't know whether the Deputy Minister would like to highlight something. with regard to the proposed new subclause 2. And we've also got the options there.
Proceed.
Thank you, Chair. Victim impact statement, clause 5. It has also been discussed on numerous occasions in the committee. I don't know whether I need to highlight anything there for the committee. And then with regard to penalties or orders, subclause 1 relates to an underlying offence as a hate crime, and the first part is general part to indicate what type of penalties the court may impose, and that is actually existing penalties as contemplated in section 276 of the Criminal Procedure Act. And then also under certain circumstances, postponement of or suspension of the sentence. So those are the general penal jurisdiction provisions dealing then with the court's jurisdiction to impose penalties. Subclause.
Honorable Chair. Honorable Chair.
Sorry, Chair. I want us to go to this one of correctional supervision, Chair, or imprisonment from which a person may be placed under correctional supervision. Are we, for example, I know that it is section 276 of Criminal Procedure. For the intention, I'm not sure, Chair, because most of the time when we take such issues, serious issues, if we give a leeway somewhere along the issues of punishment, without maybe talking bad about the courts, they always go for the lenient one, Chair. When it comes to, I don't want to attack the courts. I don't want to be seen or heard attacking the courts, Chair. But I'm worried that they always, I don't know what is happening, go for the lightest, even if it's within the criminal setup. They always go for the lighter, and others they give them harsh punishment within this. I know that it goes with the facts brought in front of the prosecutor, but I'm not sure, Chair, that how that can be responded to. Chair, I don't know if maybe I even hear myself. Can I have a comment on that one? Maybe the DM can hear me what I want to say. Thank you, Chair.
And I don't think it's an intention of this legislation to introduce a form of a minimum sentence. And I think we have burned our fingers on many occasions when we did that. We factor with the discretion of the court, because there will always be mitigating and aggravating circumstances. Sometimes we feel that the sentence was too light, but you find that we were not part even of the court proceedings, or we have not read even the court docket. I would appeal that we do not, in legislation, tamper with the discretion of the court in terms of sentencing. Maybe we can debate that, but unless we want to introduce minimum sentences, of which even in terms of the workshop that we had, we were saying that we must start in a way looking at that critically. Honorable Swart.
Chair, yes, I would be in agreement with what you are saying on that. What I wanted to raise was 6.3 on the hate speech. I see. I'm trying to follow on. It's a bit difficult on my cell phone, but can we go to 6.3? There is the penal provision for hate speech. First offense, 3 years. Second offense, 5 years. And then a proposal of 8 years. I might have missed the discussion when that was discussed, but I do think we need to consider two issues here. And that is, firstly, a number of people in making their public submissions suggested a restorative justice approach as well, given that this is a social problem as well. And I'm not sure if it's necessary to put it in legislation, probably not. I think that I'd like to just hear from the department. My understanding is a restorative justice approach can be adopted by the prosecutor. But I am a bit concerned about the 8 years and where that came from. I think I would like to know, offhand, I don't know what the sentences were imposed in the other matters on criminal injuria, but I don't think it was anywhere near that, or 3 years. I do understand it is a fine or imprisonment up to 3 years, but even that to me is quite high. To go to 8 years, I think, is a proposal for even on a first offense. And I do appreciate it is maximum. You're not determining a minimum sentence here, so the court has the discretion. But I think a court will be led by the legislature, given an indication of quite a severe sentence for hate speech, even on a first offense. But I think maybe there's more discussion necessary around this. Thank you, Chair.
Thank you very much, Honorable Deputy Minister.
Chair, just firstly, and maybe Mr. du Preez can go through it on with regard to the schedules. There is the inclusion of certain hate crimes into the minimum sentencing system. And I would argue that we've provided minimum sentences for serious crimes. Let's say, I was trying to think of them, but multiple rapes, life sentence. Should rape as a hate crime, I mean, the issue was rape as a hate crime should also be included. And how does one say, okay, multiple rape, yeah, life sentence, rape as a hate crime, no, it's fine, you can have the ordinary sentencing. There's also, we've got to be careful of the discretion of the court is there. We can't stop that, and that is correct that it is there. But I think there have been some rather strange judgments. There's one particularly from Limpopo, where an adult man raped a child, was given the minimum sentence in the regional court. In the High Court, I think the judge found a substantial and compelling reason to deviate. And maybe I'm being flippant, but and there were maybe a few more, but one of the factors was that his girlfriend had testified and said he wasn't such a bad person. Now, I have a problem with that, I have to say, with that approach. But anyway, so just to say, and Mr. du Preez can give more detail, but there is inclusion of hate crimes, not hate speech, under some of the minimum sentencing provisions in the schedule. On Mr. Swart's point of, well, there's two issues. Look, there's been debate in the committee. Remember, for hate speech, this is the maximum sentence. There's no minimum sentence for hate speech. And there's been that option, that proposal comes from some discussions that have happened.
Sorry, Jim, can you repeat your last sentence?
I was just saying on the hate speech penalties. There's no minimum sentences for hate speech. What the debate is about is what should the maximum term of imprisonment be for hate speech if it's particularly bad. How far can the court go? Just on Mr. Swart's question, Vicky Momberg got a sentence of imprisonment because I think the court found her, well, had deliberated on that. It wasn't likely imposed. I can't remember how long it was. I think she'd appealed against it. I'm not sure what the outcome was, but the issue was she was just unrepentant, I think. And I think the issue would be without prejudging existing cases, but if somebody says something really bad that devastates people, what should the penalty be? One can maybe think of current cases. Let me not say anything more on that. If somebody says hate speech, which doesn't constitute incitement, but it's still hate speech, and the result is that a number of people of that group get killed, shouldn't there be, but you can't prove that it was incitement to the killing or linkage with the killing, but criminally you can't prove it. Shouldn't there be provision for a heavier sentence in that regard? On Mr. Swart's point about alternative sentencing, look, this was a difficult area. By creating the category of hate crimes, we're saying that these are serious crimes. And we, in terms of, didn't want to emphasize alternative sentences for fear that the prosecution may go that route just because it's easier. However, nothing precludes. So this bill is saying hate crimes are serious and must be dealt with seriously, but there's nothing that precludes alternative sentences. And in fact, that list under 2 gives a whole lot of options for sentencing. I don't know though if Mr. De Preer or Ms. Buerta in particular would want to add.
Mr. Chair, thank you. I don't have anything additional to say in this regard. Thank you, Chair.
Ms. Buerta?
Thank you, Chair. I'm covered.
Honorable Masekwatshele?
Thank you, Chair. I think the Minister covered me, Chair. I think we really have to take this bill as serious as it's meant to be, Chair, even with the punishments, Chair. I think the issue of not exceeding 8 years, it was discussed, Chair, because there were other years that were presented to the committee. And the issue was that there's no base where we can say the research says this exactly, considering the discussions that we had as a committee. So, Chair, I think I would advocate that let's leave things as they are. But the only concern is that we hope that the discretion of the court will talk to the seriousness of this bill whenever they make their own decisions, their own discretions when matters come before them, as the Minister was explaining, Chair. Thank you.
Thank you very much. Would I be correct to say that you are saying that it's not, the bill says shall not be sentenced to 8 years, but it shall not exceed 8 years. So it could be anything but not be, above 8 years. So it gives some discretion to the court. It could be 3 years, it could be 1 month, it could be 6 months, it could be, but depending on the seriousness of the case or of the crime, but it should not exceed 8 years.
Yes, Chair. I think that's what I was saying, Chair, and also I think I'm not sure if maybe that issue we have covered extensively, the issue that the DM mentioned when it comes to the issue of those unrepentant perpetrators, Chair, as to they will also, in actual fact, he spoke about the issue of the schedule. If they can also look into that one for particularly for those unrepentant perpetrators, Chair. Thank you.
Thank you very much. Just before we proceed, members, can I suggest, I'm told that the report is ready. Now the time to talk about the issue of 1 o'clock, I think it's important now because we still have to approve that report. Honorable Horn, are you still going to be with us after 1?
Yeah, I don't know. I am committed to attend that other meeting. The Honorable Breitenbach indicated to me that she thinks we have a responsibility both to go there because we have been committed. I can try and stay on for a minute or two after 1, but I feel obligated since I have committed to attend that meeting to go there. Yes. It is also a virtual meeting, so I don't need to travel. Yeah, so I don't want to be seen as obstructive, but it is slightly difficult.
Yes, because in that case, I would suggest maybe at 2:15 that maybe we take a 5 minutes break, we read the report, we process it, and then the remainder of the time up to 1 o'clock we deal with we proceed with the bill, because the report is quite urgent also. Honorable Breitenbach.
Thank you, Honorable Chair. Yes, unfortunately, both Honorable Horn and I are obligated to attend this meeting, and we will try however to stay on for as long as possible. Thank you.
Yeah, can we confine ourselves to the suggestion I'm making now, that at 2:15 we take 5 minutes to read the report, it's a pager, and then we quickly at 10 to a minute, we deal with the report, and then we come back to the bill again.
That's fine, Chair.
Thank you very much. That will also cover Honorable Velma. So members, we will still break at 1. We have 3 members who will not be part of us. So let's proceed. I had Honorable Deputy Minister, Honorable Swart, Honorable Nivot Tochen, in that order.
Chair, before you go there, Chair, I hope us having to go on without those 3 members, it's not going to take us back when they come back, Chair. It's my request. Thank you very much.
No, my understanding is that we are adjourning at 1, so no one will be left out.
Thank you, Chair.
Yes, we have quite a number of, we have also Honorable Nivot Tochen who submitted her apology earlier on. Honorable Deputy Minister.
Chair, it was actually an old hand, but we've largely finished. Maybe if I can just make a proposal on the rest of the bill.
Okay.
Under 7, there's inclusions as a result of the public hearings, and that is that there should be under 7.1a national instructions for the police about how to deal with hate crimes and hate speech. It's sort of fairly, I think, clear. Then there's the issue that was in the bill about the NDPP must issue directives on relating to the prosecution. But there's also then a new provision on training courses for prosecutors. Reporting, there was nothing new. Prevention, there was just the addition of the Commission for Cultural, Religious, and Linguistic Communities. The training aspect under, I think, what am I on? Is it 8.2b has come out because that's covered by the instructions to the training done by the NDPP. And then it's regulations. We had taken out the contentious issue is we're proposing taking out the requirement of parliamentary approval, which the committee can decide to put back in. That's under 10.2. That's basically because, look, our experience seems to be, and I don't know what the committee's view is, that the committee, I mean, it's a deemed approval after 60 days, but often the committee battles to find the time to consider those regulations. And then it's basically 11, which is the schedule, which, Chair, you had indicated some unhappiness with minimum sentences, but I think it's a question of either they are in or they're out. But that's largely what's in the schedule. So I wanted to suggest that, I mean, I would have thought that we're in a position to, as well, the department would be in a position to produce early in the new year a cleaned up version of this working document. I don't know if that covers things satisfactorily for members, but I was just trying to get us to that point where we can produce a cleaned up version of the working document for the committee to consider in the new year. Thanks, Chair.
Thank you very much, Deputy Minister. Thank you for that. Honorable Swart.
Chair, thank you. Yes, just on, I'm still on that issue of 6, on the issue of the hate speech sentencing. I personally don't I must have missed the discussion on 8 years, but the proposal must be an option. Can't be, I didn't agree on 8 years. So that's an option I would submit. To me, it seems excessively high, but I don't remember the discussion. And I'm sure there was a good discussion in my absence. Then I do think that regulation, the approval for Parliament should be reinserted as an option. We need to reconsider that. And I think those are the 2 inputs from my side at this stage. Thank you, Chair.
Honorable Swart, would you, under that sentence, do you have a different proposal than 8 years?
Yes, I've got as is in the bill. So as it is in the bill, it's 3 years, first offence, 5 years, second offence. That is the bill as, and then there was an option of 8 years. But I would prefer it returns to what it was initially in the bill. I think I'm trying to find out the Vicky Marburg issue. I think she got 2 years, 1 year suspended or something like that. So it was to increase for a first offence from 3 years to 8 years is significant, substantial. And I don't know if that can be justified. Thank you, Chair. Remembering that would be for a first offender as well. But it's a I understand it's a maximum sentence, but I would propose that we return to the bill. Thank you.
So, Mr. Dupree, you have already, let's say option 1 and option 2. Option 1 would be the bill as it is. Option 2 would be the maximum period. In fact, the 8 years, not exceeding 8 years. And then it's a suggestion by Swart that Parliament must approve the regulations. The department is proposing that we don't. In fact, the approval is taken out. The department developed the regulations, and they do not need to be approved by Parliament. So those are the two options that we would have. My experience has always been that after every term of parliament, the committee is reduced to be much smaller, with still a lot of work. It might not be ideal what the deputy minister is suggesting, but I think it's practical. But let's have the two options. Because there are quite a number of regulations that are coming. In fact, there are quite a number of laws where we are saying that regulations must be approved by Parliament. And in most cases, regulations are much more detailed than even the actual bill. Sometimes the bill can be quite short and the regulations can move into tens of pages. So that is one of the things that we must also consider, and bearing in mind what the deputy minister has raised, that after 60 days, some of the regulations are deemed to have been approved. But it's something that we can come back to as we debate the options. Honorable Swart, is it an old hand or a new hand?
Old hand, thank you, Chair. Oh, sorry, just to add, in view of what you said, we also at the same time need to be very aware that we're dealing with a very contentious issue, which is hate speech. And we don't know what those regulations will say. And that's why I think it's important for us to look at it. We can prioritize it even, but I would prefer that option, that we see what is in those regulations. Thank you, Chair.
Thank you.
Thank you.
Thank you very much, Honorable Jale.
Thank you, Chairperson. I think, let me just say, we'll wait for the department to clean up this document, and then when they come back. But I will also still motivate that Chair, as the DM and the department proposed the issue of the schedule. I think we should not change that one, Chair. It should stay there. Thank you, Chair.
Thank you very much. Any further contributions, members? None. I think for today, we have come to the end of processing of this bill. Let me take this opportunity to thank the department led by the Deputy Minister for sitting with us throughout until today. We know that legislative drafting is not an easy subject. It's an involved area, but we'd like to thank you for all your assistance, and like to thank members for their contributions and hard work. We are still going to come back to the bill next year and deal with the options, and hopefully after that we would be ready to have the A list that will be voted upon. But thank you very much, members and everybody, for the spirit within which we processed this bill. And sometimes the discussions were hot, but that is the diversity of our nation and of our political system. But I think all of us, one thing that we take out from this process is that we are all enriched. No one can say that he came or she came to this process, especially in the and you came out not being enriched. Thank you very much. Can we now move to the issue of the report? Can we come back at quarter to one? Let's read the report. The report has been sent to your email addresses. Let's just read the report. Can I confirm with the Secretariat, have you sent it to all the members?
Yes, Chair. We've sent the report. I think you are cutting, Chair.
Or have you sent the report to all the members?
Yes, Chairperson, we sent the report to all the members. Thank you.
Okay. Yeah, so can we come back at quarter to one? Thank you very much, DM. the report. Interim report of the Portfolio Committee on Justice and Correctional Services on the Cannabis for Private Purposes Bill, B19 of 2020, National Assembly, Section 75, date 30 November 2022. Are there any corrections on page 1? Page 2? Page 3? Is there a mover for the adoption of the report?
Chair, I move for the adoption of this report, Chair. Thank you.
Honorable Maseko Jele moves. Any seconder?
Honorable Neo Druchen seconds, Chair.
Honorable Neo Druchen seconds. Any objections? No objection. The report is agreed to. Members, that brings us to the end of this meeting. And the end of the meetings for the term. As I have indicated that we will meet with the Secretariat, and then thereafter we will also, I'm not sure whether I should, after meeting with the Secretariat, we will circulate the draft to the leaders of parties represented in the committee. And then once we are done with that, then we will circulate the draft program, because we must wait for the programming committee. But the thematic areas that we need to cover for next year, the report that we will need to draft, that would cover our term from 2019 until now, whether it will be an assessment to check whether we are on course, what did we commit to achieve, what we have been able to achieve up to this far, what is it that we would not be able to achieve, and then what is it that is on the threat of not being achieved but is achievable if we can add more energy to it. So we need sort of a report that is going to be produced, that we can have that discussion that will help us to have clear priorities for the year. This will serve as a first draft of us preparing an exit report, because at the end of next year, we might not come back and sit as a committee in 2024. Everybody will be in an election mode, because elections will be they should be between May and it's 90 days, May, June, July. By the end of July or August, that is the maximum time in terms of our constitution. So it will not be a report like we have been doing, but it must be a report that takes stock of what we have been able to do, and then what we need to do to ensure that we meet all the targets we set for ourselves, and also to finish up the oversight visits. So early next year, it will be a busy year. So after this meeting, after this consultation with the leaders of political parties, we would be in a position to also deal with the logistical arrangements for our oversight visits. Members, one of the issues we have been asking members, led by Honorable Breitenbach, that we identify thematic areas for the study tour, and possible countries. Can we set a deadline now? And any member who would want also to add and to deposit his or her views can send that to the committee secretariat. Can we say that by the 13th of December, that should be, we should have received all your proposals, including proposals from Honorable Breitenbach, so that we can start dealing with the application processes and all of those things. Members, thank you very much for the hard work you put in your work for the year. I think it was not an easy year, but you always came through. Thank you for your dedication and for your collegiality. Thank you very much. Members, within this 5 minutes, are there any members who want to say one or two words before we adjourn? Honorable Swart, Honorable Newvold,
Chair, I just wanted to thank you for the way you've managed the committee and chaired it in a very, very professional way. I also wanted to thank the department and all the inputs from the department, their very hard work. And lastly, I would like to thank all our staff, the committee staff that have really worked very hard, and they've produced the most amazing and helpful documents. The research documents have always been very, very helpful. And from our side, I'd just like to wish you a very blessed and peaceful Christmas and a very prosperous new year. I do look forward to chatting to you about the program, but just from my side, formally, thank you so much.
Thank you very much, Honorable Newvold.
Yes, thank you, Chairperson. I would like to echo what Honorable Swart has just said. Also just to thank yourself as the Chairperson for all your patience with us as well. And thank you also to the department, but especially my the Secretariat, their assistance and their patience as well with me as a member, particularly. So thank you to everyone. Thanks, Chair.
Thank you very much, Honorable Jale.
No, Chair, they've taken all the weights. I just want to add a big thank you to everybody. Thank you, Chair.
Thank you very much, Honorable Horn.
Yes, indeed, as the Honorable Maseko Jele has said, Chair, others have expressed our feelings as well. A big thank you to the officials who really enables this committee. A thank you to the colleagues in the committee for maintaining a spirit of collegiality even amidst some dealing with potentially divisive issues. And lastly, Chair, a big thank you to you. In my role as a party whip, I sometimes need to deal with complaints some of our members have about their chairs in other committees. And then every time I deal with those, I realize how lucky we are in this committee for the fact that you embrace the true spirit of what a committee chair should be. So having said that, from our side, we also wish everybody a good rest. If you celebrate Christmas, maybe a festival in which you again find our Lord and Savior, maybe all come back rested. And for those who will be dealing with a program, please remember to put the hate speech and the hate crimes bill towards the end of November next on the agenda. Thank you.
No, thank you very much. I think it will be amiss of me if I don't thank the committee secretariat and the research unit. I really think that we are blessed to have both the secretariat and the research unit. I think they are the most hardworking secretariat and research unit that I have worked with. I know that if you have to compare yourselves with other committee researchers and secretariat, you have no weekend, you have no rest time, you have no evenings, and we don't take those for granted. But you are always more motivated than anybody else to do your work. Thank you very much. And to members of the department, the parliamentary legal services, thank you for your very good advices all the time. And to the PLOs that work with us, thank you very much. PMG and the parliamentary TV services and everybody at YouTube that always streams us, thank you very much. Members, you are always, I take you as my brothers and sisters. In fact, we were gossiping about you, myself, and Sia, and I think he made a very good suggestion, which we might maybe think about. That maybe our workshop should be physical, and we find a place outside of Parliament, like we went to at some point to, was it Stellenbosch? And so that we can also bond together. We must play hard and work hard. So we would work on all of those things, but I think in you as members, I always thank God for making me to work with such good South Africans who represent the best that South Africa wants. Thank you very much. The meeting is adjourned. Yes, 1 o'clock. 1 o'clock. Thank you very much.
Thank you.
Thank you.